Thank you, Mary. And again, I follow through with Debbie. Thank you, Mary, for your great contribution to our community. I promised Mary that I would say just a few minutes, things at the beginning about the importance of having power of attorneys and wills. And by the way, that's not just seniors. That's everybody over 18. And if you do not have a power of attorney, and you suddenly are in a serious car accident and you are not able to function and do your financial things, the government gets involved, the public trustee for Ontario. And the province of Ontario. And trust me, you don't want that. I know a situation, somebody in King, she had a stroke at 58. She only has $125,000. And by the way, you wouldn't have expected it because I think her mother's close to 90 now. But that $125,000 is held by the public trustee, and the family can't even buy a sweater for her without having it approved. So it's really important that power of attorney. I tell people you can even go on the public trustee's website and print your own power of attorneys, though it's always best to have a lawyer do it. That's how important it is. And there are two kinds of power of attorneys. One is called property, the power of attorney for property, and that one is to do with money. The other is personal care. And personal care, again, hearing Mary talk, suddenly someone in your family or yourself, you're in hospital, you can't make your own decisions. There are medical decisions to be made. You can't make medical decisions without having a medical doctor also approve them, but it really makes it a lot easier for the family if you have them in place. Now, a will, the importance of having a will. It's so important that some people I know up in Muskoka who didn't have the money to do any of this stuff, I said, I'll do it on a weekend. They told me they didn't have a will or power of attorney, and the husband at 45 was having some heart problems. I literally went on a website and made a very simple will and power of attorney for them over the weekend. And that was about a year ago, just because it's so much easier with a will. Right now I have a new estate where the deceased has no spouse or children, and his nearest next of kin will be first cousins, and they are in another country. He has another cousin who is a second cousin, and it's a small estate, but we are going to have to apply for a certificate of appointment. That's the word for probate. It's really called a certificate of appointment today. And Will is going to be Toronto, and I'm just hoping, I had to review the law myself on that as to where we go here. And because he has a cousin here, has been a power of attorney, I think we'll be able to appoint the cousin. But even a very simple will really make your family's life a lot easier. And the power of attorneys make your life easier as well, because on many power of attorneys where I've seen it happen, the people recover. One of our clients had a stroke at 79 and he recovered fully and then went back to managing his own financial affairs. So now I'll just go through the roles and responsibilities of the executor. I probably won't get through it all. It's a long list, but we'll start out in the beginning. The first one is the funeral and burial arrangements. And so the executor decides that. Often the will have some sort of direction, what you want, but really it's up to the executor. To me, that is one of the most important beginnings of the estate, because if that goes well with the relatives, then the administration of the estate goes well. There are many conflicts in families over estates, unfortunately. I used to be a litigation lawyer in Mississauga before coming back to my farming community. And I tell you, I beg people who look like they're going to start fighting to not do it, to settle it, to somehow not get into the high legal fees of litigation, but also the delay, the years that are involved. So that burial arrangement is pretty important. If the family members, if you were an executor, if I were an executor, I would be talking to them about, are they happy with what's happened? And we have a new estate where the executor was setting the time of the funeral at 10 o'clock in the morning, and one of the nieces got very upset and very angry email that she wouldn't be, it's too early for her, et cetera, et cetera. So the executor changed the time. So now the niece sent a nice email back. I think emails allow people to say things they might not normally have said. The second was locate the beneficiaries. So for example, in the new estate where this man, all his relatives are in Italy, we're going to have to find the names of all of these beneficiaries. Now, most of our families here, we probably know who they are, but you need to locate them. If there's a will, those beneficiaries will be named in the will, so you should be able to locate them. Then the next one is locating and valuing the assets. I've had estates where literally people bring big boxes of papers in, and we go through them all to see what's there. And often they're life insurance or bank accounts that people don't know anything about. In fact, one fairly large estate, there was an extra $500 sitting in a Royal Bank in Newmarket that we eventually found by accident. But you really do need to look through all of that and see what's there. Often we'll find, for example, if someone worked for a company that provided some sort of benefits, there'll be a death benefit in the company, even if you haven't worked there for many years. The one I was talking about where all the beneficiaries in Italy, we found a $5,000 benefit through the company he used to work for. So and life insurance, I had another estate where we had no money. In fact, I agreed to pay the funeral at the time. This was about 15 years ago, because I just didn't know what else to do. We had no money, and the family was there. I got all these papers, sent a bunch of letters, and we found $15,000 life insurance in a company that the woman had worked for before. So again, if you have the opportunity now to organize, the best is to organize your papers, and I try to do it every January 1st, January 2nd. I try to sort of make sure I got everything in a certain place in my house, and I sort of look at my will again. Now, I've got a husband and 2 children, so my will's pretty easy to do. But right now, both my sons are living out of Ontario. One's in Vancouver and one's in Calgary. So I had to make sure I had a clause in my will that said, because they will be, they eventually, I guess, will be executors, that they do not have to post a bond. The court could make you post a bond if you are an executor out of Ontario. And I had to do that once. And that's a hassle for a brother-in-law where I was the only one that could do it. It was Northwest Territories, and at the time they insisted to be a lawyer. So here I was doing this. And it was quite a process, getting a bond. You had to list all your assets, all your debts. They had to, if you had a credit card, they wanted to know how much was owing on it. And the bond, of course, guarantees that you will carry on the estate. Somebody else is going to talk about executors, but it's important. We are seeing people live a lot longer. The number of people living well over 90 and many 100 or close to 100 in King and around the surrounding area is a very high number. So when you're looking at executors, you want to make sure that the age thing is going to be there, because again, we had another one where one executor was 59, one was 95, and we had to deal with things, and the 95-year-old was having some issues, and we were going to have to bring a court order to get her removed, which we really didn't want to have to do. She passed away, but the will had an interesting clause. It said that if one of the executors died, of the 2, they had to substitute, I'll say his name, Uncle Orville. And Uncle Orville lived in northern Alberta. And by this time, he's 88, and he's living in a senior residence. He's just gone into a residence. So what do we do? What we did is we sent a release out there to him, had him see a lawyer. He said he didn't want to be an executor. And fortunately, the court agreed in Newmarket. They might not have. Actually, it wasn't Newmarket, it was Oshawa. They might not have. They might have said, the will says you have 2 executors, you better get another executor. These are sort of the problems. These cost money for people, they cost delay, and a lot of stress for the executors, by the way. So again, going through and locating the assets, you're looking at, like certain assets are not part of the estate for probate purposes, like joint assets, if you have a joint house or joint property or joint bank accounts. Now, there are some joint bank accounts that do need to be distributed under the estate. And there are 2 Supreme Court of Canada cases that have gone different ways. And one said that a joint account was a true joint account with the daughter, and the other one said because the daughter and the mother had both used the account. They both deposited money, they both wrote checks on it, used the money. The other, they said, belonged to the estate because it was the mother's estate and only the mother had used the estate. It was only her money going in, it was only her expenses. So again, you want to think it out carefully, and you might even want to put that in your will. People do that. They put in the will, any accounts I have joint with anyone, I intend it to be that way. I mean, something to that effect. Okay, so you're looking for insurance policies and death benefits and other benefits and pensions, and again, it's always a surprise what we find when we go through these boxes of assets. Now, if you have to apply for probate, and when I say if, often between spouses, everything's joint. And you can actually set up an estate where everything's joint and there is really no probate. You might have to register your deed of your house or other property, but you don't have to spend the money and time of probate. And I'll tell you how important that is. I got a call the other day from somebody I knew fairly well. Said her husband was dying. He's a young man. He has cancer, and there's one asset. Everything's joint except one asset. And he has been married before, so he has children from first marriage, and he wants that to go to the 4 kids. I got that call, what is that, Thursday morning. Thursday night, I was in Alliston getting that deed signed with all 4 kids. I'm happy to say they all showed up. But that's how important it is. And he actually said to me, how much am I saving in money? And I sort of went through, and when I came back to the office and did the probate fees and all this sort of thing, it's probably $12,000 or $13,000. But it's not just the saving the money, it would have been the hassle. The courts are taking between 3 and 4 months right now to get probate. And I'll talk about, well, I can talk about that right now. After you get probate, and again, it's 3 or 4 months, we get lucky every so often and it's a month or 2 months, but generally the 3 or 4 months. And that's in fact, Newmarket was sending their probates to Oshawa, and Barrie was sending theirs to Bracebridge. It gives you an idea of the kind of volume, I guess, they've had in the last few years. But after you get probate, you would open up an estate account. That's provided you have probate, or it's actually called a certificate of appointment of a trustee. And the estate account, for example, one of the things is the Canada pension benefit, which is $2,500, I think some are $3,000. That'll be payable to the estate. So you usually have to open a estate account even for that amount, although the bank may allow you to sign an indemnity and have it signed off. Then, January 1st, 2015, the Ontario government brought in a new law, and we now have to file within 90 days of the probate an estate information return. Now, when I talked about everything being joint, and that's especially between spouses, I mean, you can easily set that up. In most cases, that's good. And if you had a small account of $20,000 in your own name, the bank usually would not require probate. They just have you sign a release that under the will, you're the right person to get the bank account. But when you have probate, you have to, within 90 days, file, it's called an estate information return. And this is a very interesting return. The reason they brought it in, apparently people were being dishonest about valuating estates. So people would say in their estate the house is worth $200,000, it was really worth $2 million. So now, if you have real property, you have to get at least 2 evaluations of the land, and you show the impact value. And we then often have to pay more probate fees at the end of that 90 days because of the valuation. So the one I just talked about running off that day to get the cottage to the kids, this man is in hospice. So you know, it's not like we wonder what's going to happen here. He really is going to, you know, die in a few days. If we had not done, we would have had to get probate. It would have taken 3 or 4 months, and then we would have had to do this return, which means the clients would have to go to a real estate agent and get the evaluations. And when you file this form, the estate information return, you actually have to have the 2 evaluations. Right now, we've been lucky, and they have not questioned any of ours, but you put the evaluations in, and that's what you pay probate fees on. But then you also have to have copies of all the bank accounts and investments and all the other assets. In that return, in the small print, it says that you must get a valuation of even bicycles. When I went to the course in Toronto, when this came in January 2016, I think it's, yeah, 15. I ran off to Toronto on a Thursday night to meet with, on a course on it, and there were 150 lawyers from across Ontario. That's how important it was, from as far as Thunder Bay. And when they said bicycles, everybody in the room, you know, showed our displeasure with that. But I guess there's some bicycles that are worth $10,000. But also a car. You have to get an evaluation of a car. And we had an estate recently where the only car was a 2002 Honda, and I tell you, we had trouble getting an evaluation on that. I'll tell you what they're looking for there. They're looking for expensive jewelry and things like that. But if you had a boat, antique car. And there are some ways around that, that you can have primary and secondary wills. And so if you had really expensive toys, as I call them, or you have corporations, you can set up a will to avoid having to go through this whole process. But even that, there's a recent Supreme Court case that I've just got on the wording of those primary and secondary wills. So, but there is a way of getting around that hassle. And again, I had another estate where the man, I didn't realize how sick he was, and we ran off, and we did it quite quickly, primary and secondary wills. And the good news is I didn't realize he had 8 companies, but we would have had to get evaluations of all those companies, and they had, you know, little pieces of property and machinery and everything, and we didn't, because when we set up the wills in the original, we had a primary and secondary will, one dealing with the corporate assets and one dealing with the rest of the estate that needed to be probated. And often we do corporate assets, we're also dealing with jewelry and things like that. All right, next part of your job is executor. And by the way, being executor is a really hard job. I've done it, and I think I said to Mary, I won't do it again. I'm going to have to be a very close relative to do it again. It's a huge responsibility. And somewhere there's supposed to be a year executors. We have a year to get it all done. Well, all I can say is good luck with that, because you need if you're an executor as a lawyer, not as a family member, you'll want a release from Revenue Canada. You'll want a clearance letter to make sure that there's absolutely no liability to Revenue Canada. And I'll tell you, that's probably going to take more than a year. So, so your next step is to determine the debts and liabilities. And I know Amy this afternoon is going to speak about that. We spoke on the phone, just the importance of advertising for creditors. Now, in families where they know the debts, and we see people with their 100 or 95 or 96, and they're absolutely sure what the debts are of the estate, they often don't advertise. And it used to be very expensive. In the newspaper, it was $800 or $900. Now you can do it online, and I think it's $140. But that's an important thing. And again, the box I talked about, you'd be going through that box, looking for any of the debts and anything that's owing. And the other thing, I'll just go for both assets and debts, you go through the bank accounts. You could see in the bank accounts, you know, if somebody is getting a pension. And you also will see the kind of expenses. And there may be expenses in there that you need to cut off, like Bell Canada, or, you know, some automatic deductions that need to be done. You settle the debts, and there's a clause in the will about settling the debts. Fortunately, I haven't had many problems with that, but you could have debts where that you have to sue or something. Then we go down to distribution to the, after you get the tax clearance from the government, and you've got all this done, then you get down to distributing to the beneficiaries. Now, somebody, at the beginning, I guess Mary talked about accounting. I cannot tell you how important that is. If you're an online person, you get QuickBooks or something and you record if you're an executor, you record every single cent that you get in or pay. If you just want to do it in a book, do it that way. But the beneficiaries could, if they wanted to, ask you to account for every single cent. Now, I had and this is where they have the right to ask for a passing of accounts. And the passing of accounts means you have to show all this money in accounts and it goes before a judge. And I had one in Newmarket a few years ago where the other lawyer was questioning a $151 Bell Canada bill. Fortunately, we had the receipt. But it was, it's that kind of detail. And I think it's fair to say that there's a fair amount of conflict in families. So, I'm seeing a smile down there. And people are saying it's, millenniums and it's more recent and stuff, but I can tell you in my family, the Black family, I found some stuff back in the 1800s, so where they were fighting. In fact, my great-great-grandfather, John Black, who was a farmer and also was 1837 rebellion participant as a young teenager, he became a justice of the peace. I think you'll like this, Deb. I think because he was liberal, because I don't think he had much education, but he became a justice of the peace. And I found as a teenager, I think maybe it got me interested in law, all these documents on estates. And because I knew nothing about law, I didn't even know a lawyer. And I found all these documents on estates. And then I found a book that he had written in, as they did in the 1800s, where he mediated estates in this area in King. So there's nothing new going on with the disputes in estates, but it really, it's important that people try and get them sorted out in the beginning. I'm not sure lawyers are the right people. We've been trained to fight. I've been trained to fight. I used to be a litigation lawyer, but not now. I want to see these settled because 4 years later, when you've spent $100,000 on legal fees, you're not going to be very happy. And by the way, that's on another question, talking to a client, is how many executors do you have? And, think about that beginning. I've always thought that all the children should be involved, but that's a lot. If you've got 3 or 4 children, that's a lot of people to be signing documents and meeting with people. So one is probably easier with an alternative, of who it will be. And in families, if you're going to appoint one child, you'll need to have the discussion when you're alive as to why you're doing that. Often it's the youngest or the oldest or some sort of thing, but there's often a lot of resentfulness in families when one child's appointed and others aren't. And we see it quite commonly, I have a twin sister, and we're very close, and we're best friends. In fact, she was calling me as I was leaving this morning. But I had given up my successful law practice in Mississauga to move home to look after my father and live a quiet life, which didn't quite happen. And I was power of attorney for him because I was here. She lived 4 hours away. And when he was dying and, I had the power of attorney, she said to me, "Why are you the power of attorney?" Now, because I had seen all these fights in estates, I quickly said, "Oh, no, it's just because I was here, and, you're the alternate," and we remain best friends. But if I had reacted in another way, it might not have been so good. So then you go through the estate, and you'll need to sell assets, and that becomes very important. Like if you're going to sell a house, the beneficiaries think you didn't get a good price, you could be liable as an executor. So again, you'll want to be very careful. Even the contents of the house. I have an estate right now where looks like they're fighting over the contents and they're not worth a lot. And we're trying to figure out what to do. I'm telling the executor to sit down with the 4, they're all grandchildren, sit down with them and work out a deal. Have them go to the house, have them pick out things, see if we can do it that way. Some people, but you could get yourself into litigation over not doing a fair distribution. And then On the accounting, I guess we've been through that now, but the accounting is, you need a lawyer and an accountant for sure when you're doing these things. And then to make sure that you are keeping every single cent. You know, keep a file of all the receipts and all the money coming in, all the disbursements. And certainly you'll want an accountant. I was going to say you need a lawyer, an accountant, and probably a bottle of scotch if you take on this job. Maybe one bottle won't be enough. And then you need to file the returns, income tax returns. And often with people we see in their late 90s, there's a very small amount owing. But we had an estate where somebody, a Canadian, died at 101, a man in Texas. And he had set up a trust, so we didn't have to probate a will. But the hassle of that, it took over 2 years because of all the tax returns that we had to do in Texas. And he had an accountant there, but it was amazing just watching that and getting it converted. And that's another thing when you're setting up a will. If you have assets out of Canada, you'll want to talk carefully with your lawyer about that and probably have a will in that, jurisdiction. Even if you have wills in another province, if you have an asset. I had one recently where we have a property in PEI. So we got probate. Then what we do is we call it reseal. So we have to send it down to a lawyer down there who sends it to the court in PEI, and they reseal the certificate of appointment or probate, which means it's valid down there. And I had another one in Florida where we had to do that recently. And then there's, I already mentioned, but there's the tax clearance. Now, executors are paid well, but, and I've had executors say to me, well, I'm not going to take anything. I said, wait till we finish the estate before you say that. Because I'm telling you, when you're down to, Revenue Canada and sending the forms and all of that, it can be very, very stressful. And that tax clearance, as I said earlier, can often take quite a long time.